Barrage Scott, who is approaching the podium. Mr. Scott, please state your name for the record.
Well, I was gonna say Scott, so.
How you doing, Brian?
All right, just glad to see my family in here. That's all.
Thank you, Judge.
Been here every time for you.
Yeah.
All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report. Scott is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
But also stipulate the defendant's comment.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'd be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was.
All right, everyone, it's courtroom time again. And today's spotlight is on People versus Barrage Scott. Scott steps up calmly, even giving the judge a polite good morning like they're old pals. He seems happy to see his family watching from the benches. Always a good look when the judge's eyes are on you. The hearing today is about a competency review, which basically means the court's checking if Scott's mentally fit to face trial and understands what's happening. Good for him. The report says he's all there, in plain English. His head's clear, and the case moves forward. The judge signs off and sets the next step. A probable cause conference, which is like a warm-up round before the real trial to see if there's enough evidence to proceed.
At the time of this alleged event, he indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks that he's asking for potential release.
Response.
I would ask that bond remain as currently.
Now Scott's defense lawyer takes the floor. Time for the heartfelt pitch. He explains that Scott's had a tough run with mental health, but is doing better these days. He's taking his medication, has his family behind him, especially his grandmother, and is open to any treatment the court suggests. The lawyer even asks if Scott could be placed in mental health court, a program that focuses on recovery instead of punishment. The message is simple. Judge, he's not trying to run. He just needs a fair shot. Scott even agrees to wear a monitoring tether, basically saying, I'll prove I can follow the rules.
And I appreciate Mr. Easter's advocacy on behalf of his client. I'm struck by the, I think it was in the competency report. Mr. Scott, volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of suffering. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and as individuals.
Nothing further, Judge.
All right. I am going to,
Then the prosecutor stands up, and the mood changes fast. They remind everyone that Scott's criminal past isn't exactly clean. According to the evaluation, he even tried pretending to have memory problems, acting confused to dodge accountability. To the prosecutor, that's not someone who deserves sympathy. That's someone who knows how to manipulate the system. You can feel the air tighten in the room. All eyes on Scott now.
deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters, and typically I can let Mr. Scott out of custody, may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since it's
You understand what he's saying
a
to you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I
week later.
know, but he keeps saying the same thing.
Okay.
Saying the same thing that he said.
Okay.
He's not.
I believe Mr. Scott wants to address you directly, Your Honor, if you don't.
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor is saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests, and the first one he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me.
And just like that, the judge makes his call. Bond stays exactly the same. No reductions, no breaks. He points out that Scott already got a chance before, and less than a week later, landed himself back in hot water. You can hear the frustration in the judge's voice. It's not anger, it's disappointment, like a teacher saying, I gave you a chance and you blew it. This time, the judge isn't gambling on trust.
In no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed.
Scott finally speaks up, emotional and trying to explain himself. He insists people are twisting his words, that he cooperated fully during his evaluation. Then his voice softens. He talks about losing his sister at a young age, falling into addiction, and how that pain pulled him down the wrong road. He says he doesn't want jail. He wants help. He promises to stay busy with programs and self-improvement if given another shot. For a moment, the courtroom feels quiet, like everyone can sense the real person beneath the case file.